Welcome to Know Your Rights New Jersey. I'm your host, Ronald Ponder. Today we continue our discussion on hot topics in immigration, especially given the uncertainty under the present administration. We are going to discuss specifically H-1B visas, and to help us bring some clarity and some practical information regarding these issues, we have here with us today David Nachman and Luka Zimochek of the NPZ law firms, of which they are both principals. Welcome, guys.
Thanks so much for having us.
Well, thank you for joining us. Let's get straight into understanding what H-1B visas are. Give us a little idea of the nomenclature. What are they, and why are they important?
Well, the H-1B is a non-immigrant work visa, which is really a temporary opportunity for foreign nationals to come to the United States and work in professional positions. And really what it comes down to is what is the definition of professional. And back in the day, which was before they changed the legal standard, it meant a person with distinguished merit and ability. And that sort of, over time, has morphed into an individual who is a professional who is serving in a specialty occupation. And that's the sort of vague area that you get into is the individual a professional, and are they serving in a specialty occupation in the U.S.?
How does the system work regarding H-1B visas? How do you obtain those?
There has to be an offer of employment, so a beneficiary needs to have an offer from a company for a specialty occupation position. There has to be a minimum of a bachelor's degree, but it's very important that the position itself must require at least a bachelor's degree. So you could have a beneficiary or individual having a PhD or master's degree, but it's not sufficient. The position itself must be professional. And the minimum is a bachelor's degree, U.S. bachelor's degree. Okay, so either one of you or both of you, so why is there such great fear in both the business community and amongst immigrations regarding what is happening today?
Well, it's a great question because what I think a lot of people fear is that the H-1B non-immigrant work visa is used to displace U.S. workers. And so one of the things that I think that unfortunately the media doesn't fully talk about when they talk about H-1B visas and this concept of displacing U.S. workers is that there's something called an LCA, a labor condition application. And it's an underlying application that gets submitted to the U.S. Department of Labor where the employer has to prove that the individual who's taking the job has to pay the federally mandated prevailing wage. And so there's a protection that the individuals who are being brought in will not be displacing U.S. workers because the employers have to pay those workers the federally mandated prevailing wage.
Okay, so that addresses the fear of those who may be impacted or believe they are impacted by the hirings of these employers. But why are the business people, why is the business community fearful, and why are the non-U.S. workers fearful? What is happening today?
Well, I think that what you're seeing, at least in large organizations, is that people are being brought in on H-1Bs as contractors. And what they're doing is, and this is what happened in Florida, I think it was about a year or two back, where individuals for a large household named organization, which has a television station, as you know, and what they did is they brought contractors in who were sitting side to side, and what happened was the U.S. workers were training their replacements who were going to be contractors. And I think that the media grabbed onto that and made that a really big hype. And that's where all of a sudden it took off into, these individuals are displacing U.S. workers, because there's a whole I guess you would say a subculture in business of these contractors who are on H-1Bs being brought in for huge organizations like and again, household names in the contracting field.
Now, I also understand that the business community is saying that what's happening in the current administration can be harmful to business, really harmful to business, as opposed to harmful to U.S. workers. Well, I'm specifically thinking of McClatchy. Can you tell us a little bit about that? Or
I can't.
Okay.
Okay.
Well then, tell me.
Yeah.
Well, actually, let's skip on to something else.
Okay.
Tell us a little bit about the what is happening in April. Why is April important?
So on April 1st, all the H-1B, new H-1Bs are filed. So H-1B petitions need to be received on April 1st, and typically they do have a lottery because there are a lot of applications that are received. For example, last year there were about 200,000 applications for H-1B. There are only 65,000 H-1Bs available for each year. Even though we've seen a decrease, because I think 2 years ago it was 236,000 H-1Bs, still it's a less than 50% chance to get it into the lottery.
Okay.
So it's very important to get in for April 1st, because that's a deadline for H-1B.
Is there anything you'd like to add to that, David?
So essentially what it is that there's a lot of difficulty, I think, both for employers and employees, because they just don't know whether they're going to get these H-1Bs.
Okay.
And so for us, we're seeing a lot of folks who we have to actually start to talk to them about backup plans. You know, if you don't get the H-1B in the lottery, what's your backup plan? What are the other alternatives?
And what are you telling them? Well, can you give us an example of what you might be telling them their backup plans might be?
Yeah, so
the perfect one is, for example, O1 visa. So whoever is very high skilled, they have great credentials, researchers, scholars, and they have a lot of publications, great credentials, they would qualify for O1. That's a visa for extraordinary ability individuals. So that's a great backup because there is no deadline. You can essentially apply it at any point. That's one.
That's one. Another one that we often talk to our clients about is the cap-exempt H-1B, which is for academic institutions.
Right.
If you have an academic institution that's doing H-1Bs, they're not subject to the cap. So they can be doing they can be non-cap cases year-round. And then you also have a situation where if individuals are seeking extensions on their H-1Bs, then those extensions are also exempt from the cap. So that's important to know. And then there are other types of scenarios, like there's you can use maybe the e-visa, which is for treaty traders. Those are for investors where they are coming in to open up their own businesses. That might be an option for some people.
Okay.
There are also other types of visas, like P visas for individuals who are doing something that's culturally unique. So we as immigration lawyers go through with the individuals who we're talking to, both the employers and the employees, and creating a strategic plan for them. And usually it's trying to figure out also how that strategic plan works into the timing, namely that we know we have to get those H-1Bs in on April 1st, but we also know that come, when we hear, whenever that will be, and we're probably premium processing is going to be taken offline again this year, where you can't premium process the case. So this year we didn't hear about our H-1Bs until I think it was like mid-June, early July.
Some cases October, and
right.
they started for the H-1Bs October 1st.
Okay.
So it was a problem because there was the first year actually in many, many years where they took off the premium processing.
So obviously you guys work very closely with both the employers and the employees.
Yes.
Exactly. Sometimes we will come into understanding the needs based upon an employee reaching out for us, saying this is what we need. Oftentimes it's the employer who says we have identified X number of, could be one, could be several foreign workers who have a specific skill set, one that cannot be found in the U.S., and that's usually what they're reaching out for us to try to use the H-1B for that particular skill set.
Now, earlier in your answer, you mentioned extensions. Now, my understanding is that there's some problems and some fear around the 6-year disallowing the extensions. Can you explain that to us?
Right, so that was the reference that you made to McClatchy before.
I knew we'd get around to it.
You send me into a bit of a tailspin. But, yes, so that's interesting because that's sort of a nuance which it has to do with what's called AC-21, and maybe Ludwig can explain how the how that works and why it sent all of the employees into a tailspin, because they've been relying upon these extensions for years, and now all of a sudden there was this pullback, and I think it scared everyone.
Yes.
Yeah,
So
please.
H-1B is valid for 3 years initially, with the possibility to extend it for additional 3 years. In total, 6 years, and that's it. Now, as David mentioned, there is a provision in law called AC-21, where allows employees to get 3 or 1 year extensions beyond the 6 year if they start the green card process. So this is mostly about these people that have had H-1B for years, could be 12 years, 15 years, because they are waiting for a green card. So essentially the law gives them an opportunity to keep extending the H-1B until they finally get the green card. So this is mostly for Indian nationals, Chinese nationals, because these green card visa categories are backlogged, retrogressed. So it takes years. It could be 10 years, 12 years, depending on how many people apply for a green card. So this would be really terrible for them, being here for 12 years,
So
15 years.
So what happens if they don't get the extension?
I don't really think that it's going to go there into not having the H-1B, because they're in line for the green card.
Okay.
So they have their place for the green card, and I don't really think that the government meant to take these people offline.
Yeah, I think that they just sent a chilling effect, and I
Yes.
think that they put it on the agenda, on the regulatory agenda. I believe that that's where the announcement came and just scared everyone. But then I think they backed off and realized, I think that, and that was the recent announcement, is that they have backed off that and decided, not to go in that direction. However, I think what it does is it shows us just how tenuous some of these regulations are and how things can change so quickly. And that's really sort of the general business immigration environment right now, where there's so many different things that are going on. We have the recent announcements about the termination of TPS, which is temporary protected status for Haitians and El Salvadorians who have been in the United States for a decade, for decades. And here all of a sudden, I mean, they've been, since 2001, this program's been online, and now they're just announcing that it's going to be offline. And it's basically sending everyone into a tailspin. And
Now, when you say offline, what do you mean offline?
it means that after September 9th of 2019, they won't be able to extend their TPS status in the U.S. So a lot of these folks are looking northward. A lot of them are looking to Canada. A lot of them are trying to figure out whether they have other benefits. So we have folks who are coming into our office asking us about, I would say, asylum claims. A lot of people asking about asylum claims. A lot of people asking about family relationships and what the impact of the family relationships are on their ability to get status in the U.S. Now, as you know also, the president sent out that message about chain migration, that he's not very happy with chain migration. He actually, I think, likened chain migration to family immigration, which is what it is. And
Well, with that, I'm going to halt you there
Please,
because it's time to take a break. But we want to talk a little bit more about that, a little more extended. Welcome back to Know Your Rights New Jersey. We're here with Lutka Zimochek and David Nachman discussing H-1B visas. Let's backtrack a little bit and tell us about the H-1B visa process so we have a better understanding of that.
The company or the petitioner files a petition, as we mentioned, on April 1st. The petition is being processed either premium processing or regular, depending on what the government decides. Last year there was no premium processing. It takes months. With regular processing, could be 5-6 months. Typically, we should have a decision by October 1st because employees will start on H-1B on April 1st. If the employee is here in a valid status, let's say they have F1 student visa, they're on OPT, or any other valid non-immigrant status, they get changed. Their status get changed into H-1B automatically on October 1st.
Okay.
So they can work here, they can stay here, no problem at all. However, the minute they want to travel, let's say they need to go home
Right.
to their home country of, for example, India, they are not allowed to travel. They would have to go to the US consulate in India and to obtain multiple entry visa stamp.
So what's been happening when they do that? It's an administrative, give me the terminology.
Administrative processing.
Okay.
There's a lot going on right now. It's called 221G,
Okay.
and there are a lot of problems lately.
Why? What's happening?
So basically, people are stuck. They apply. They have to make a formal application at the consulate and apply for H-1B. They already have approved H-1B petition. So they're just applying for H-1B visa. The U.S. consulate can decide to do a review of the company, review of the LCA, just review everything to make sure that it's all correct.
Right.
There is a fraud unit as well. And this, unfortunately, could take days, weeks, months. I've had a case that's
Well, since
been a
the
year.
current administration, has it been any more difficult than it had in previous years?
Definitely. It's definitely
Absolutely.
longer, and it happens a lot more.
Well, tell
Yeah,
us a little bit about that and why.
It comes out of that executive order that President Trump passed back in January of 2017,
Right.
which is Buy American, Hire American. And there was this discussion in there about extreme vetting. And extreme vetting has manifested itself in a variety of different ways in the immigration arena, where it's caused tremendous slowdowns of the process. For one example, at least domestically, is that we're noticing that all cases now, before it was only family-based cases that needed to be interviewed, now employment and family-based cases are being interviewed. So that's one slowdown.
Well, tell us a little bit about how long does it take to get your interview? Is it immediate, and how long is that part of the process?
Yeah, it's definitely not immediate, but
because there are not enough
we'll-
resources to do them.
Exactly,
Right.
but we'll take an immediate relative case where, let's say
Okay.
you have a U.S. citizen who's marrying a foreign national. They file the case. It takes about 12 months probably to get to an interview. We're noticing it was, and the district office in New Jersey had tried to get it down to about 6 months, and they were doing
Even
a
at
pretty
3
good job.
months.
They had it at about
Even
3
3
months. They were
months.
really good, and now they're back to, I think, about 12 months now. On the,
Yeah.
At least that's what we were telling
And New
people.
York even worse.
And right, and New York's even more
Yeah,
than
longer.
a year. So, and that presents all kinds of logistical issues. For example, one of the things that you have to submit when you do an immediate relative case is a medical, and those medicals expire in 1 year. So now we're telling our clients not to do medicals and to hold off and to do the medicals later on in the process. So it's just everything has slowed down and presented new frustrations for both clients and also for lawyers. who
So
are
does
doing
this force non-U.S. workers not to leave the country?
Yes. Oftentimes they don't want to leave because they're worried. Nobody can guarantee, obviously we as lawyers cannot guarantee them how long they're going to stay abroad. And let's say they have a vacation 10 days, 2 weeks. Sometimes they're going to stay 3 months, 4 months if they're going to be placed into administrative processing. The government does not have a processing time. They can take however long they want to.
And the reason also has to do with, there are various levels of scrutiny when you're doing these checks. So, for example, there's one called the technical alert list, where if an individual is doing something in the U.S. that is related to some sort of technical area that the government has an interest in, they have to vet the person to make sure that they're not a threat. Then there's something called a visa eagle, there's something called a visa donkey, there's a visa mantis, and these are various layers of potential. It actually comes out of a database that the U.S. Department of State has. So it's kind of interesting from the standpoint of the way it's designed. I mean, the process is designed where the U.S. Department of Homeland Security blesses the case, and then when the individual goes to the U.S. Department of State abroad, which is the consulate for their visa, there's the checks and balances, and that's what's going on. So they're making sure that it was done properly.
They don't have right to deny it. They will not deny the consul. They will not deny the visa application. However, they will, if they don't feel that it's okay, they're going to send it back to the U.S. on a notice of intent to revoke.
There seems to be a very anti-immigration stance in how the system is now operating, which leads me to what seems to be another impediment in the system, and that's this request for evidence. Tell us a little bit about what's happening with that.
So request for evidence has always been around. Obviously, they would request evidence. This year, however, there was a big boom of certain type of a request, and that was a level 1. So it was a wage issue.
Well, let me back you up a little bit. What is a request for evidence? Why? Where does this fit into the process, and what is it? And obviously, you're telling me it slows down the process.
Certainly. You submit petition with required documents. Let's say some documents are missing, so they would request documents that are missing. For example, a copy of a visa, I-94, passport, degree. But then you have certain things that they come up with, and this year, this was the level issue, where they have additional questions. So it's not even the evidence that they're asking for certain documents, it's they have questions. And this year, as I mentioned, that was the wage problem, which was a level 1. So basically, the government was saying that if the employer requested level 1 as a prevailing
level
wage,
1 wage, in other words, the lowest level wage,
the lowest salary, then it's probably not a specialty occupation, and then it doesn't qualify for H-1B.
Wow.
so
that
they
was
put
a
you right
big
into a
thing.
corner. Yeah, they were arguing you into a corner.
And pretty much, I would say about 50% of cases
Are level 1s?
received requests for evidence
Oh, okay.
Yeah.
on this type of issue.
And so what does it do to the cases, this request for evidence?
You get about 80 days, about 3 months to respond, so it's going to slow down the case, definitely.
A lot of times it required us to go out and get expert reports because we had to go out and seek wage experts who would testify that the amount that was being paid to the individual was the correct federally mandated prevailing wage. In other words, that if a level 1 wage was chosen by the employer, maybe the employer chose that level 1 wage because the individual, for example, was a student coming out of school and then going to work. Although they may have some kind of a specialized skill, which you would think intuitively would, bump that wage up, they still were an entry-level employee and therefore should be entitled to choose the level 1 wage.
So if the employer would require, for example, 5 years, bachelor's degree plus 5 years of experience and maybe some type of supervisory skills, the level would go up. But if they require only master's degree and the position requires minimum of a master's degree, then it would still be level 1.
So does that force the employers to do anything to protect this interest?
Well, I think what the employers are realizing is that they have to be a lot more careful about the way that they're designating the federally mandated prevailing wage. And what we're doing is we're working closely with them to help them to understand. I think that in the past, it was almost taken for granted that they were just going to do level 1 wages and the government was not going to question it.
Because it was specialty. They thought you were focusing on the specialty and not the wage.
Exactly. And some of the RFEs actually focus, I think probably most of the RFEs that we've seen focus on the specialty occupation. They say, prove why it's a specialty occupation. I think Ludger mentioned that. And so you spend this great deal of time explaining the nuance of that skill set. And then all of a sudden you're back into, okay, so if it's such a great skill set and it's so desirable and there are no U.S. workers who can do that, then please explain to us why you're choosing a level 1.
Well,
so the focus changes.
So do these cases stay with one decision maker or who's making these decisions?
Well, these are officers who work for the U.S. Department of Homeland Security.
One caseworker per case, or?
There are hundreds of officers in the various offices. We have the Vermont Service Center, which is where they were processed. They're going to be moving them now to another, Nebraska. So there are service centers that are located throughout the country, and I believe that there are probably thousands of workers in those service centers.
So you guys work directly with the service centers, yes or no?
Yes.
And so you're not only emailing, but you're also communicating by phone with.
Well, I think I wish we had that kind of access.
Oh, okay.
Not,
so this is what.
It's not that simple.
Yeah, unfortunately, you cannot get anyone on a phone. Premium processing is better, but this year we had no premium processing, so basically there was no communication whatsoever.
Well, I didn't want to waste time with this comment, but as you're talking, I'm thinking about people who apply for foreclosure relief here in the U.S., and this request for evidence would lead me to another question. Once you provide the documentation, the report, is that the end of it?
Sometimes.
And sometimes
and
no.
sometimes not. Yeah, exactly. Yeah.
Sometimes you get a second request for evidence. We've seen it. So you would respond, and they would come up with new questions. So you get second request, and generally speaking, in about 60 days, you get a decision.
Yeah, but that's not, I think that's more of an aberration than it is the norm. Generally speaking, you respond to the request for evidence, and then you'll get a response back from them, either yes or no.
Or no.
Yeah.
Okay, so we're nearing the end. What is it that you really want your, other than all of the fabulous information you've given us so far, what would you like to leave the viewer, particularly the employers and the foreign workers who are impacted by H-1Bs with? Whether that has to do with representation or what they should be doing, what do you want them to leave them with?
Well, I think certainly one of the most important pieces of this is that if you're going to be doing an H-1B, you want to seek out competent counsel, someone who is familiar with this type of area. It is a nuance within the immigration field, as many of the areas of immigration are developing as specialties. This is also a specialty. But also, I think that Ludka had mentioned before, is that, we're coming up on April 1st. It's the filing deadline for the lottery. It is going to be a lottery. I always say jokingly to our clients, if you're not in it, you can't win it.
But it's true,
right?
It's true.
Right? And so, unless you have a strategic plan, I think, obviously plan to be in it on April 1st, right? That's critical.
So the time to start is just about now. Now is the time to start preparing, compiling all the documents. If the foreign national has foreign credentials, we would have to do credential evaluation.
Yeah.
So the time is right now, January, February. March could be too late.
Okay.
Because it takes time to prepare it. Just LCA, as David mentioned, takes about 7 days to get approved.
And we've noticed in the past that actually what ends up happening is that the system gets so jammed up in March, the LCAs, it could actually take more than 7 days to turn the LCA around. So why wait that long? Start to plan in advance.
Yeah.
Don't wait till the last minute. So.
Great. We greatly appreciate having both of you here. And
Thank you so much.
As usual. And thank you for joining us. Until next time.